The case you are about to see was tried in the Northeast. If it were tried today in California, some of the company's people might face jail. The California Corporate Criminal Liability Act makes it a crime for managers to fail to inform regulatory agencies, employees, and the public about serious concealed dangers in products, services, or workplace hazards. Penalties are not a slap on the wrist or fines that can be written off as a cost of doing business. Convicted violators face up to 3 years in state prison and up to $25,000 in fines. Convicted corporations can be fined up to $1 million. If your company is doing business in California, producing, marketing goods or services, or employing people, it is more important than ever to be fully aware of the product liability preventive measures in the following case study docudrama. At the conclusion, I will outline California's statute. It affects every company in the world doing business in the largest state of the United States, and it may expose you to criminal liability if your product harms.
The injuries to Mrs. McRae were the direct result of her position at the moment of the flash and explosion. As others have testified, Mrs. McRae was kneeling with her arms outstretched, attempting to restart the machine. The explosion threw flaming fuel and melted plastic up onto her hands and clothing, hair, and face. As chief resident and admitting physician of the Regional Burns Clinic, I performed the initial examination. Mrs. McRae had received third-degree burns, over 65% of the upper half of her body. The left side of her face was more damaged than the right. All tissue on the left side of her head, the left ear and eye, nose, and lips were virtually destroyed. There was some vision in the patient's right eye. The scalp would require skin grafts, and hair loss would be permanent. All tissue on the neck and chest was severely burned, with indications of irreversible damage to the lungs. 2 fingers of the right hand and 2 fingers and the thumb of the left hand would have to be surgically removed immediately.
A big product liability lawsuit involves tragedy for many people. The Continental Products case began with the tragic story of Marie McRae, who suffered burns while using one of Continental's most important products, an Astro Model A76. As the case developed, the men and women who created and marketed the Astro brand were on trial as much as their product and their company. For managers like them, and for their customers, their companies, their fellow employees, their communities, and their industry, there are tremendous benefits when their products perform. The Continental case shows the other side. Immense penalties for everyone when products harm.
Mrs. McRae's blouse and hair ignited. The flammable liquid and plastic formed a jelly-like napalm, which clung to her arms and face. Smoke and toxic gas combined with shock rendered her unconscious. It was several minutes before the flames could extinguish. Therefore, I
This is not a pretty story. It doesn't have a happy ending. In fact, in this report, it doesn't have an ending at all. The point to this report is not how the trial ended, but how it started, and how the lawsuit and the accident that caused it might have been averted. Product liability has become big news. Every year, tens of thousands of suits are filed. Hundreds of jury decisions award more than $1 million each. Products are pulled off the market. Manufacturers file for bankruptcy protection. Liability insurance rates skyrocket. Some products can't get liability insurance at any price. There are calls for changes in the legal system. The case of McRae versus Continental Products Corporation was remarkable in the seriousness of Marie McRae's injuries and in the size of the claim. But in many ways, it was typical. The result took a heavy toll on the company, its industry, and on the lives of the executives who developed and marketed the Astro A76. The Astro Products division included some of the best people at Continental. Our report will focus on the leader of the original Astro product group, Vice President David Rouse.
I didn't have to be in court to hear Marie McRae's story, but I was there. I felt I had to be. It was very hard to take. We weren't in business to harm anybody. It just didn't seem possible that a group like ours could be responsible for an injury like this. We were Continental's A-team. The high flyers, the ones who came up with the innovative ideas and made moneymakers out of them. The Astro A76 was our baby. It became our lives. I remember the moment the A76 was born. My research and development director, George Mattson, and I were having lunch, and George sketched his new concept on a paper napkin. I could see the possibilities right away. We'd just taken our kids to the Air and Space Museum in Washington. First name that popped into my head was Astro. And the National Bicentennial year was coming up, so Astro 76. I kept the paper napkin. A year later, I had it framed, hung it on the wall, as a reminder of how it all began. We were made into a product group and went into high gear. Mattson's people engineered designs and prototypes. My quality control director, Tony Riccio, began testing them. I considered both George and Tony careful and very dedicated engineers. Steve Powers, my marketing director, worked up sales projections and staked out our share of the potential market, a very ambitious share. Now, that was Steve. Never think small. My advertising director, Ruth Devens, a brilliant, really creative promotional mind, put together an award-winning campaign, all red, white, and blue. Later, there'd be sick jokes like, what's red, white, and blue up? An Astro A76. We hit the market right on cue, the 4th of July, 1976. By the first of the year, we knew we had a winner. Competitors tripped over themselves trying to make a shinier, more desirable version. The next few years, we improved it. Introduced 2 new models. Became a division. I became a vice president. We accounted for a bigger and bigger share of Continental's sales and profits. For 10 years, Astro was the new product story of the industry. And then there was this terrible, horrendous accident.
It is now 2.5 months since Marie McRae was injured while operating an Astro A76 made by Continental Products Corporation. This afternoon, Mrs. McRae was moved from the Regional Burns Clinic to the Suburban Rehabilitation Hospital. Their attorneys say the McRaes will sue Continental Products. The damage claim is estimated to be in the millions. Representatives for Continental were unavailable for comment.
When we first heard about the accident, we had been shocked and saddened. But in our eyes, our product definitely was not at fault. That's what we told Continental's corporate lawyer, Harrison Clay. Harry, I feel very bad about Mrs. McRae. We all do. But I don't think the blame should come down on us. Now, our sales and marketing group has done some research on the unit that injured Mrs. McRae. Steve?
This machine is 10 years old. It was purchased used. The previous owner had modified the machine by removing a safety guard, which also held a warning label. The instruction manual had been lost. We believe the unit was improperly operated and maintained.
Ruth described how cautionary information was displayed on the product and on all packaging, promotion, and instruction manuals. Tony laid out quality assurance tests that showed Astro was safe. The product complied with and even exceeded every federal and state safety regulation at the time it was manufactured. Steve Powers said any accidents his distributors and customer service reps had reported to him had been minor. Never an injury as serious as this.
Well, judging on what I've heard this morning, this looks defensible. Apparently, we can show it was not our fault. We may be able to demonstrate that it was the operator and prior owner's fault. Now, we'll make a strong statement to that effect to McRae's attorney, along with an offer strictly pegged to medical and rehabilitation costs, plus 10 or 15%. Well, that's a substantial sum of money, largely covered by our insurance. And Mrs. McCrae will be well cared for. Well, thank you, everybody.
As the meeting broke up, there was a general feeling of, that's that. But the McCrae's lawyer rejected our offer and brought in a well-known specialist in product liability lawsuits, Hughes Brackett.
Hughes Brackett's law firm had a long record of successful product liability judgments and huge awards. The McCrae Continental case had moved into the big leagues. Brackett retained a burn specialist who concluded that Mrs. McCrae faced years of reconstructive surgery, rehabilitation, special care, and a high probability later in her life of other health problems related to her injuries. A forensic economics expert estimated the amount of the damages, medical treatment, therapy, lifetime care. The computerized file of the American Trial Lawyers Association revealed lawsuits with other products like Astro, manufactured by competitors. Advertisements in major cities brought phone calls from dozens of people who had received very minor injuries in similar Astro accidents and who hoped to be part of a class action settlement. Brackett's associates traveled around the country to meet with a network of attorneys from other law firms to share information on pending claims against other companies. Investigators contacted former Astro employees who might testify against the company. The litigation team studied Astro documents the McCrae's attorney had acquired during discovery. Accountants calculated that Continental's sales, earnings, and assets were the highest of various corporations in this product area. The decision was made to increase the claim against Continental to $15 million, including $10 million in punitive damages.
From what we've uncovered so far, and we're just beginning to dig beneath the surface, Continental's Astro division has been behaving negligently and recklessly. They've been playing with fire for years. This year, somebody got burned. And now Continental's going to pay for the way they've been doing business.
But you haven't told me just
From the minute Hughes Brackett entered the picture, defending our case and ourselves became the focus of our lives. Continental brought in an outside defense lawyer, Charles Bryant.
Now, all of you, especially your engineers, George, are going to be working very closely with Charlie.
Charlie, let me get something off my chest right away. We've been called in the media and in court reckless and negligent and out to make a buck at all costs. Not true. And we're sore. It's this mouthpiece who's reckless and out to make a buck. Now, is there anything we can do about statements like that?
Probably nothing. Now, I understand how you feel. Product liability suits hurt. And one of the biggest hurts is publicity that makes you look like bad people. But it hurts even more when the plaintiff's lawyers try to make you look bad in front of the jury. So, we need to look for ways to use your record to defend against that. Now, a case like this goes through several preparatory stages. In discovery, as you've already found out, you're required to turn over documents requested by the plaintiff. Interrogatories from the plaintiff present questions which have to be answered in writing. And there'll be depositions where you'll have to sit down with their lawyers and answer questions under oath. In a great many cases, the suit is settled during these stages and never reaches the courtroom. Now, you've already turned over a good many documents to the McCrae's family lawyer, but Brackett has requested more, many more. Engineering drawings, reports, personal papers, sales records, field reports, every sketch and note.
Dave, it'll take a forklift to move all this stuff.
What the devil are these people looking for? The smoking gun?
Well, that, and for a lot of bits and pieces that they'll try to put together into a picture of reckless disregard for safety. Now, by the way, make sure you preserve all records, no matter how trivial or insignificant or damaging they may look, even if you consider them to be personal and private property. Make sure that nothing is destroyed from this moment on. Any gaps in your files can look very bad. To a jury, it can look like a cover-up. To put up an effective defense, we're going to need a lot of information. For starters, a history of product development and a list of everybody who had anything to do with design, development, production, and marketing.
It was a long meeting, the first of many. We had a lot to learn. We thought all we had to prove was that we weren't negligent. We learned about strict liability.
If they can show that the product that you've manufactured was defective and caused harm, you can be held strictly liable for damages.
We thought defects were mainly a production line problem. We learned there are 3 kinds of defects that can make a product dangerous in the eyes of the law.
Defects in design, defects in manufacture, defects in warnings and instructions. Now,
we learned about the manufacturer's duty to warn. We learned about our post-sale responsibilities. We learned this case would be our lives and our careers for months to come. Working on the case was time-consuming and costly. As more and more documents came to light, people were on edge. Charles Bryant was finding problems in our records.
And we want to find evidence at every stage where your division has acted to prevent accidents and protect the public. And we are finding that. But we're also finding documents where other considerations appear to be given priority over safety.
for example, design. You ever see this handwritten note signed TR? That'd be Tony Riccio, your quality control man, right?
Yeah.
It says, problems, problems. Maybe George should design a fire extinguisher into it. This was stapled to a test report about a small product fire in the testing lab.
That's Tony's idea of kidding. Drives George crazy. What happened was, when we started production in 1976, Riccio's quality control people would pull machines off the assembly line for reliability tests. One of the tests was to start and restart each unit over and over again. And a valve on one of them jammed. The technician fiddled with the valve, spilled a little fuel, and there was a small flare-up. No big thing. But that same night, we had a design review. Event spills of this kind.
It's pretty late in the game to be discovering a design defect. Kickoff is in 2 months.
We're ready to ship the first 10,000 units.
Let's do whatever's necessary for safety. Tony, is redesign necessary? If it is, we'll...
No, not a full redesign. I didn't say that. We need some sort of a fix, a guard or a shield.
I don't agree that there's even a 1 in a million chance, but to protect ourselves, we can add a shield here to prevent spills from igniting. Here are 2 designs. Plan A can be screwed on to the 10,000 units in inventory.
We'll have to unpack a few thousand of them to do it.
Plan B is more complicated, would have to be welded on.
What's the cost factor?
Rough estimate, Plan A would add $725 per unit. Plan B, $37.50 per unit.
$37.50. Our market share, our whole plan is based on holding the price.
From a safety standpoint?
From a safety standpoint, they both do the same job. Plan A is removable, Plan B is permanent.
But they do the same job.
The same.
Well, in view of the unit cost and marketing, I think we gotta go with A. So the hazard was practically nil. We immediately reviewed the design. We added a safety guard. Now, doesn't that demonstrate that safety was top priority?
Well, depends. I hear a lot about unit costs and market share. Did you test designs A and B to see if they were equally safe? Do we have records of those tests? If you didn't test or keep records, what does that say about your attitude towards safety? Was your concern to prevent accidents swept away in your rush to market? That's how the jury is going to be asked to look at it. So there are problems in design. Now, in the second area, warnings and instructions. Starting 9 months after Astro was put on the market, customer service reports show that some operators were removing the safety guards.
It was a little clumsy to operate with the guard. So we added a safety label warning that the guard should be in place before operating.
I have no objection to a warning, but words like danger and fire hazard, explosion, serious burns, and a cartoon. 2 of our competitors have machines that don't carry warning labels like that. Why should we have to? We'll be handing them a share of the market. Scare our customers away. Look, if it's that dangerous, we should take it off the market.
No.
Not paper over the problem with a label.
No, absolutely not. The A76 and the 77 are safe and reliable. If they weren't, I wouldn't have let them out of the shop. This is a precaution.
So we're just covering ourselves with this labeling. Then why are we using words like danger and fire hazard, explosion.
Instead of danger, could we say warning? And instead of fire hazard, can we say replace safety guard before operating? Let's see. To prevent flammable fuel spillage. And let's drop the cartoon.
Better, better. It's still pretty explicit.
Okay.
Did it occur to you to ask someone in the legal department whether they thought the wording and design covered your exposure in case of litigation?
I doubt it. We consulted legal on contracts, compliance with regulatory law, patent rights, on legal matters. This was a technical matter.
With legal implications.
Yes, I can see that now.
That explains why there are no lawyers involved in meetings like this one. You know, there are standards for label designs.
Of course, I know all about them. And we follow them now. But this was 10 years ago. There were no standards.
Well, one issue in this case may be your responsibility to update warnings on older products to conform with current safety standards. This gets us into the third area of concern, follow-through on products in use. Now, on an agenda for a meeting dated during the third year of production, why has somebody written out in ballpoint pen, recall, $290,000 at $10?
Now, this was not an item on any agenda. It was just talked about and was dropped. Well, the question is, what do we do about the machines we sold for the past 3 years? Recall?
Well, there are 290,000 units out there. Recall and retrofit will cost $10 per unit.
Even if it didn't cost anything, recall would have a very negative effect on our brand image.
Any other accident reports like this?
Not really, all small stuff. Settled with replacements, refunds, that sort of thing.
There are almost 300,000 units out there, all working fine. And we've got, what, basically 2 reports of accident of this kind. We're talking recall. Now, if you follow the instructions, this thing is practically idiot-proof.
Well, they're idiots and they're idiots.
What kind of an idiot operates this kind of a machine without reading the instructions?
Lots of idiots, George. Me, for instance. But I agree, our machine has a great record.
Okay, that's it for recall. Costly, bad for the brand, technically not called for. Next item.
But you never followed through to prove that the recall was technically not called for. Did you know that one of your people recommended a recall letter to customers warning of a hazard? All we have is a handwritten draft, no typed version. No indication of response or follow-up, not even who wrote it.
I know who this is. An engineer, pain in the neck. Not with us any longer.
That's what you think. The plaintiff has found him, and his dissenting opinions. So far, we have no record of the company responding to his dissent in any way.
He sent us back to see if we could uncover any supporting documents.
You won't believe this. One of my people actually has 5 file cabinets just like this. Reports, memos, notes dating back to day 1. It's mostly duplicates of papers we already have, but there's his notations on everything.
Now, stuff like this shouldn't have been retained for more than a year. We have a standard company-wide policy on that. How could this happen?
Oh, that's Archie. He saves every word he's ever written and anything that has his name on it.
You're going to have to read all of his notes.
Take days.
Gathered about as much
Depositions
information
were
as
coming
we're
up.
going to be able to get, so it's
Brian prepared us to testify for Hughes Brackett.
You and a number of your people are going to be deposed. Now, this will be going on for the next few weeks, mostly here in this room. Oh, by the way, don't attempt to counsel or influence your people to respond in any particular way. I'll give you some simple guidelines on how to handle yourself when your time comes as a deponent. The most important is very basic. Tell the truth. Now, the second step.
Brackett began by deposing some of the minor players in the marketing department. A customer service representative described how she followed up on routine product failure complaints. An artist from the advertising department was asked about early versions of package and warning label designs that had not been retained in company files.
Mr. Riccio, most engineers keep a chronological journal of their work. Did you?
I have a diary of my work, but it's my own personal property. I keep it at home.
Mr. Bryant, we would like your client to produce the diary.
The first time I discussed the concept with David, we were having lunch, the two of us, and I sketched it out on a paper napkin. As a matter of fact, he still has it.
Dave, you have a document you didn't turn over during discovery, a sketch on some kind of a napkin?
This is a document? Well, I can hear what he's going to say in court now. They did their R&D in the back of a napkin, right?
Talk about
The strain was growing. I hated to see what was happening to what had once been a close-knit team.
Ship it out. Exhibit space was scheduled.
You people wanted to sell this as much as we did.
All right, knock it off. I don't want to hear this from anybody. Our mission then was to put out a good product, a safe product, and we did it. Our mission now was to make the jury see that.
Astro's day in court was actually many weeks. Hughes Brackett lived up to his reputation. He presented a mass of exhibits and a parade of expert witnesses.
So in your expert opinion, Professor Miller, due to the operator inconvenience factors you've described, could it have been anticipated with a high degree of probability that some operators might remove the safety guard? Now, as a customer service rep, you said you handle a great many minor complaints each year about product failures, accidents, small injuries. Were these ever followed up, to your knowledge, by anyone? Now, in your expert opinion as a behavioral psychologist, Dr. Green, would you say the wording on this label, its placement on the unit, the design and size of the lettering, is adequate to alert and warn the operator about the hazard and its consequences? So before you quit Astro, as you said in disgust, did you propose an alternative design that you felt anticipated ways the product could be misused and that might endanger the operator? Mr. Rouse, pages 89 and 90 in Mr. Riccio's private journal describe the Astro fire accident in his test lab. The next day you received this recommendation from Mr. Riccio. Where would you read it for the jury?
Problems. Maybe George should design a fire extinguisher into it. That wasn't a recommendation, it was a wisecrack.
Through day after day of expert testimony and industrial design data, the case had become very impersonal. On the last day of the plaintiff's case, it was wrenched back into personal perspective. A videotape, narrated by her doctor, took the jury through one day in the life of Marie McRae.
On the day you see here, Mrs. McRae will report to the clinic for skin grafts. These will continue for many years. When Marie was first admitted, the burned outer skin was removed under sedation, and the stripped areas were then covered with pigskin and cadaver skin, attached, as you can see, by stapling. With therapy, the remaining fingers and thumb of the right hand have regained some flexibility. The digits to the left are still rigid and may never improve. Marie requires assistance from her husband and a full-time nurse to get dressed, to eat, and to perform any other bodily functions. Mr. McRae helps to put on what we call a jost, a custom-made elasticized head covering to compress the scars on her face and head. Some patients will always feel more at ease wearing this as a mask.
Will the officer please call Marie McRae?
Turn and face the bench, please. Raise your right hand. Do you promise that in the testimony you're about to give before this court, you'll tell the truth, the whole truth, and nothing but the truth, so help you God? Be seated.
Just for the record, Marie, would you give the court your name?
My name is Marie McRae.
And where do you currently reside?
1535 Elm Street.
Now, some of the money we've asked for is simply to care for Marie. Some of what we've asked for is punitive, to punish Continental Products Incorporated for some of the management decisions and attitudes you've heard about in this courtroom. The defendants, these executives here, have tried to say to you, we did all we could do. What more could we have done? What more could they have done? They could have followed through on what they knew. They could have redesigned. They could have warned. They could have recalled. Why didn't they do any of these things? Why do you think? You heard their words. Could scare sales away. Might lose 10% of our market share. Bad for the brand. Too costly. What kind of an idiot doesn't read instructions? Aren't people who use words like these negligent, reckless, wanton, willfully disregarding public safety? Think of those words as you decide how much of a price this giant corporation should pay for putting that time bomb into the unsuspecting hands of Marie McCrae.
Charles Bryant rebutted the picture of Astro executives as reckless and negligent. He reviewed the defense that showed David Rouse and his people as competent, concerned, and responsible. The jury had to decide between these conflicting pictures of motives and actions.
You've been here,
how would you decide?
Listen to the testimony. You know that's not true.
Design and development. Did the company take sufficient care to anticipate the way their new product might be used or misused and take steps to prevent accidents in either case? Or were they negligent in their urgency to meet marketing target dates?
You know that there were problems with the Astro, yes?
Safety review. Did the company's response to test lab reports show a high priority for safety or a wanton disregard of safety in favor of sales considerations?
But you also know that the difficult
Wording of warnings and instructions. Was it demonstrated that the sole intent of warning language was to prevent accidents? Or was the wording intended mainly to cover the risk of lawsuits?
The difficulty with design was correct.
Safety label design. Were safety labels designed to alert, warn, and instruct the product user? Or was the duty to warn treated as secondary to design and brand identity?
There was no pressure to do that.
Post-sale follow-up. Were reports of accidents and safety problems in older products followed up by a serious consideration of recall and retrofit? Or were they recklessly rejected without further study because of cost and damage to the brand image?
They also ran into some difficulties with the label and the instructions.
Document retention. Why were cartons of routine records going back to the very first thumbnail sketch of the product retained by the company, while some records relevant to safety problems were destroyed? Was there a willful attempt to cover up bad documents?
Where you have heard all of the evidence.
If you were charged to decide these issues, you could find the product reasonably safe and the company not negligent and award no damages at all to Marie McCrae. Or you could find the company was somewhat negligent and award an amount sufficient to pay treatment and rehabilitation and expenses. You could find the company responsible, although not negligent, and award compensatory but not punitive damages. Or you could find there was a flagrant or reckless disregard for public safety and award compensatory and punitive damages up to or even more than the $15 million asked by the plaintiff's lawyer. What would it be? We said at the beginning that the jury's decision had a terrible impact on the company, on the industry, and on the lives of many executives. But this report does not focus on the jury's decision, but on your decision. How would you decide? And as the jury deliberated, many in the courtroom wondered the same thing and wondered how things could have been different.
What's on your mind at a moment like that, or a lot of might have beens, a lot of should haves? I should have done this, I should have done that.
Late one night, it was just before the trial began, Charles Bryant, our defense attorney, and I talked about the should haves, and he said something very interesting to me. He said, "Dave, sometimes you business people treat lawyers like an emergency room. You ought to look to them for preventive medicine. It's up to you to decide in advance that you want your lawyers on your team during the product developing and marketing process. If you call in lawyers after the fact, it may be too late for preventive medicine. All they can do is try to patch you up." Well, I knew the jury decision wouldn't patch things up for Marie or us. At least I thought the verdict would settle things. We caused harm, someone got hurt, and we paid. But inside you, things don't settle that easily. Did I put a time bomb in the hands of Marie McRae? On that one, in my mind, the jury's still out. I don't think it will ever come in.
As a result of the Astro case, the company faced heavy damage payments and penalties. In California, Astro managers also might have faced jail. In 1990, the state of California enacted the Corporate Criminal Liability Act. Under the law, companies and managers can be prosecuted for criminal violations if they fail to notify regulators about safety deficiencies in their products or services. Responsibility for employee safety is also covered. The law affects all companies doing business in California. Convicted individuals may be fined up to $25,000. Even more threatening, they may be sentenced to state prison for up to 3 years. Corporations may be fined as much as $1 million. 2 actual cases illustrate the kind of corporate behavior targeted by the California law. In one case, company managers learned that their product concealed a serious danger that could cause death or bodily harm. After a cost-benefit analysis, managers calculated that eliminating the danger would cost twice as much as settling the estimated death and personal injury claims. The product was left on the market without reporting the hazard. According to federal figures, 26 deaths resulted. In another case, managers of a processing plant knew of life-threatening hazards in substances used by their employees. They failed to notify regulatory agencies or the employees. Deaths and personal injuries resulted. In California today, both these companies would be criminally liable. The California law provides that a corporate manager or employee who acquires actual knowledge of a serious concealed danger in a product or service must inform the appropriate regulatory authority in writing within 15 days. In the case of workplace hazards, the employer must inform in writing the California Division of Occupational Safety and Health in the Department of Industrial Relations and all affected employees. The notification must be immediate if the danger is imminent. Corporate personnel affected by this criminal law include people with management authority for product or service safety, research, testing, and people involved with business practice and workplace safety. The law is directed at any person who acquires information that would convince a reasonable person that, in the language of the law, quote, the normal or reasonably foreseeable use of or the exposure of an individual to the product or business practice creates a substantial probability of death, great bodily harm, or serious exposure to a hazardous substance, and the danger is not readily apparent to an individual who is likely to be exposed, unquote. Employers may be found guilty of a crime if they fail to make all their workers aware of any workplace hazard that threatens life or limb, and inform the appropriate regulatory agencies in writing. The manufacturer, service company, or employer must inform whichever government agencies are appropriate to the particular hazard and circumstances, including California Department of Industrial Relations, Division of Occupational Safety and Health, California Department of Health Services, California Department of Agriculture, California County Departments of Health. For the United States, Food and Drug Administration, Environmental Protection Agency, National Highway Traffic Safety Administration, Federal Occupations Safety and Health Administration, Nuclear Regulatory Commission, Consumer Product Safety Commission, Federal Aviation Administration, Federal Mine Safety and Health Review Commission. The law provides that this notification is not to be used against any manager in a criminal case. For a product manager, designer, developer, tester, service or process manager, production or division manager, or labor relations manager, the meaning of the California law is clear. Hiding product defects or service hazards is not just risky business, it's a crime.